Welcome to this presentation of how do I transfer a guardianship or conservatorship in Washington State. First, just a reminder that guardianships and conservatorships are court created, so any transfers must be approved by the court. Transfers can be location-based or jurisdictionally based or person-based. We'll cover 4 types. First, from one county to another county, all within the state of Washington. Second, we'll cover from one state to another state. Third, we'll cover from one jurisdiction to another jurisdiction. And lastly and fourth, we'll cover person-based changes. Let's say the individual was hospitalized in Seattle and the hospital started the guardianship in King County, but the family members are in Spokane and want to move the individual there. Or perhaps they've already moved them to an adult family home in Spokane. If the situation is stable, it makes sense to transfer the guardianship from King County so they can use the local court system. They'd need to file a petition in order in King County for change of venue. Here's a snip from the Washington State court forms. This is the petition in order to change venue. Always check for the most recent form and use Word and not the PDF if there's any chance you want an attorney to review it. There may be some minor administrative charges and filing fees depending on the circumstances too. Let's discuss changes of jurisdiction. This is when the individual moves across state lines, for example, from Washington to Texas or from Ohio to Washington. It's also used when transferring from state court to tribal court, even if there's no change in residence. For example, the individual is in the exact same adult family home in Snohomish County, but they are going to change the court system from Snohomish County Superior Court of Washington to Tulalip Tribal Court. The process for a change of jurisdiction is a bit more involving, and I'd call it a very polite dance. There's a lot of checking back and forth. You'll need to petition in the originating jurisdiction, petition in the receiving jurisdiction, get provisional orders saying, hey, if you accept, we'll accept. The petitioner must meet qualifications in the receiving jurisdiction. And then there's a final order in the receiving jurisdiction, and then you'll have to close the action in the originating jurisdiction. Here's a snip from the Washington State database with the forms. Again, always check for updates. Washington State follows a uniform law for this process. The third type of transfer we'll discuss is person-based. Examples include changing the guardian from an aging parent to a sibling, from an aging parent to a certified professional guardian, from a certified professional guardian or CPG to a family member that's discovered someone became the guardian of their relative after the fact, but they are otherwise qualified and interested. The high-level process is petition the court, give notice to all parties, ensure the successor nominee meets all qualifications, which isn't always an issue for the CPG. Sometimes a court visitor and the attorney for the individual is appointed, sometimes not, and then there's a hearing on whether this all makes sense. The process can be expedited if the transfer is to a certified professional guardian known to the courts. Thank you for watching this video on how to transfer a guardianship or conservatorship in Washington State, and let us know if we can help. As per usual, consult with an attorney in your jurisdiction for advice specific to your situation. Thank you.